Hi, my name is Scott, and I'd like to welcome you to the My LD Coach 2025 September-October LD Topic Lecture on the Plea Bargaining topic. This topic lecture is broken into two parts. This is the first part that is going to talk about the history and background behind the criminal justice system and plea bargaining. The second part is going to talk about different debate arguments and analyze which ones may be more strategic than others. My hope is that whether you do progressive debate, traditional debate, or any type of LD debate anywhere, that this first part will be very helpful in giving you some general knowledge and information that will help you succeed on the topic, and I hope you enjoy. Thank you. So the exact wording of the September-October 2025 LD resolution is resolved in the United States criminal justice system. Plea bargaining is just. Now, let's break this resolution down. Let's look at the key terms to what exactly we're going to be debating. I think some key terms in this resolution are the United States, criminal justice system, plea bargaining is and just. And I'm going to get into why I think that right now. So first, let's talk about the United States. First, it says in the United States. Generally, the United States refers to the 50 states plus the territories. So you could have affirmatives that could talk about the criminal justice system in Puerto Rico or other places that are not states. The other thing that you could definitely consider when looking at the United States as a word in this resolution is that there's no actor. It doesn't say federal government. It doesn't say an actor should do something. It just says in the United States. So I think that one of the key takeaways from this term, especially when related to criminal justice, is that it could be any criminal justice related topic in the United States. I think that this is important because there's no distinction versus the state versus the federal government versus the states. And I think that this is really important when we talk about the court system and criminal court because different states have different rules, different regulations than other places. So the United States is going to be a very important term. I also think that criminal justice system is going to be very important for a number of reasons. To break this term down, the criminal justice system is a relatively new concept. It was created in the late 60s by LBJ. And the key word that I want to start by emphasizing here is system. The criminal justice system is made up of three major components. I see this as the 3 C's in a lot of the literature: cops, courts, and corrections. So basically, criminal justice system has 3 components: law enforcement, police, the judiciary, the court system, and the prison system. Now, this would have been really, really, really important if the AI topic was chosen because it would mean all of these things. However, I think that the way in which plea bargaining works is probably going to limit this down. However, let's look at criminal justice system as a word for a second. So there's a lot of people in the literature who don't like the phrase criminal justice system and use the terminology of a criminal punishment system instead. Basically, the reason for this is that these people who are accused of a crime face a punishment rather than justice. And this play on words is an important idea to think about when we approach this topic. The other thing to think about is that there's different ideas of what justice means. Is that a punishment? Is that supervision? Is that discipline? Different criminal justice systems have different ideologies. So if this topic was about Europe, it would probably be more about rehabilitation because their criminal justice systems work very different than the United States does, which is mainly focused on punishment. The other thing that is really important is that it says criminal justice system and it does not say civil justice system. So this is important because these debates are not going to be about two people suing each other. There's no Judge Judy that settles the dispute between two people. We'll get into this in a little bit, but criminal law and criminal justice and all of these terms are very, very distinct from one another. And when you approach the topic, you should definitely take these into account. The other thing to think about like I was saying before, is that the criminal justice system is just huge. It encompasses a lot of different things, from the police to the courts to the corrections and all of these different aspects. And while this could have been huge if we had the AI topic, I think that plea bargaining sort of limits this down, because it's probably going to be more focused on the court aspect of the criminal justice system rather than the policing and corrections. Now, that will play a role. There will be different arguments about that, but I think that that will narrow the topic down a little bit for us. I also think that, like I was saying, the topic is just big and includes everything. And going back to what I was saying with the United States earlier, I think that criminal justice system could be important because I think people could define this as either the federal government's criminal justice system or the state governments or different states. And I think that this is a very interesting aspect for how you could define the topic in the criminal justice system to try to gain an angle or some strategic advantage on this topic. But I think that the term criminal justice system in itself is not limiting or exclusive. It just kind of includes everything. So, this topic has the potential to be pretty large. Now, I think that that is majorly limited down by plea bargaining. So the concept of plea bargaining is that there should be a negotiated agreement, although sometimes it's maybe not negotiated, but basically a prosecutor offers a defendant a lesser charge or a lesser offense or a decrease in their sentencing time or whatever the more lenient treatment that they are given is in regards to them pleading guilty. So basically, if they plead guilty, if they plead no contest, if they give up their right to a trial, they are given some sort of concession in their charges, their sentence, something of that nature. We'll get into that a little bit. But basically, the defendant, the person who is accused of the crime, waives their right to a jury trial. We're going to get a lot more into all of this in a little bit when we talk about plea bargaining in the criminal justice system. But basically, this allows the court system to reach a conviction without a trial. It is a type of trial avoiding mechanism, but it does rely on the defendant's consent. So if the defendant says, I don't want to take the plea bargain, they can go to trial. That is their right. Now, one of the things that's important here is that not all pleas are necessarily bargained for. So there's the concept of unbargained for guilty pleas, Alford pleas, which I'll talk about in a little bit. But the general concept behind this is that in some way, shape, or form, the defendant is, quote unquote, pleading down some of their charges for admitting guilt. So plea bargaining, some sort of understanding, an agreement, an exchange where the defendant exchanges their guilty plea for a decrease in the charge, a change in the facts, a sentence reduction, etc. I'm going to talk about all of these a lot more in the background section of this video, but just know that plea bargaining, while it seems pretty basic, there's a lot to it that could get a lot more complex, and it is not necessarily a static concept. It is something that changes and is dynamic depending on which court system and sort of what day it is almost. So that is plea bargaining. I think that the word is also very important. I wasn't going to put this in here at first, but I think that it is very important because I think it denotes that it has to be the present tense. I think that this is interesting because it might make it so that affirmative teams might not be able to reform because you just have to defend plea bargaining as it is right now. I also think that this also means that it's not about the future, it's not about the past, it's about the current system. So I think that you could use this word or definition of this word to your strategic benefit in a lot of different debate scenarios. The last word that I want to talk about is just, and I think that this is interesting, and it comes from the word justice. It's kind of the idea that individuals should be treated fairly. What is fair, right? That is the idea that, we should be righteous in how we treat people, in our integrity, in all sorts of aspects of life. I think that this is very interesting compared to past topics that we have had, because it's not necessarily a topic that is about morality. Justice or just is more about acting in a meritful way that allows you to act in a way that is just, maybe not in a way that is moral. And I think that the other thing that is also interesting about just in the resolution is that there's no actor that has to be just. It's about this system. So I think that the word just is going to be very important in this topic, especially for value criterion style debates, philosophy style debates, because this word is going to change how the framework, how the values work in the debate. I think that maybe util will be a little less strategic or successful than it has been on past topics because there's no actor, there's no government that has to be moral in a situation. It's just talking about the concept of plea bargaining. The last thing I want to note in this just section is that it is not the definition that is like simply or exactly or only. It does not mean like just a little bit. It means justice. So I think that that will be an important term for looking at this plea bargaining topic. That's what I've got on the definition section. Now we're going to look at how the topic actually functions. Let's start breaking down the background behind this topic by looking at the criminal justice system, just kind of giving us a little background into how this works. So we said the criminal justice system is broken down into three components: the cops, the courts, and corrections. Plea bargaining is going to limit that down to mainly talking about how the court system functions. Now, sure, there's going to be some aspects of policing, there's going to be different aspects of corrections, but mainly we are going to be focused on the courts. So when we look at the courts, in the United States, there's two main systems for how courts work. There is the federal judiciary and different state courts. So let's start by talking about the federal courts. So the federal judiciary has very limited jurisdiction. It can only rule on things about the Constitution, on federal law, but it has a distinct system for how this works, where a case starts in the district courts, where the country is divided up into different districts, and then they work their way up into the Court of Appeals, and then eventually, if deemed necessary, all the way to the Supreme Court. Now, the states have a very similar system, but this just works within their own state. And again, every state kind of works a little different from one another, but most of them have a similar structure where they have trial courts, often called superior courts, that kind of focus like district courts. Then they have appellate courts and a state Supreme Court. So there are kind of two criminal justice systems going on, one at the federal level, one at the state level, and it's going to depend for what you are talking about on this topic, which one of these is going to apply. So I think that knowing both of these and having some background is going to be very, very important on this topic. So if we look at this even further, if we look at how a sort of courtroom looks like in one of these criminal cases, there is the judge, there's the defendant, you have the defense attorney, the counsel, that is the person who is representing the defendant. Now, it is noteworthy that in the Supreme Court case, Gideon versus Wainwright, that there was a ruling that says that you have the right to counsel. So if you cannot afford a defense attorney, you are provided one. That is called a public defender. The next term is really not used. It's the plaintiff. Really, in these cases, you're going to hear prosecutor instead. The reason for that is that in criminal cases, the government acts as the plaintiff. Again, it is not Judge Judy or Judge Joe Brown where two people are suing each other. It is the government accusing somebody and that person being defended by their attorney. That person who is trying to convict them is often called the prosecutor. They work for the government, and typically they work out of the district attorney's office. So the district attorney, we'll get into that in a second, but those are the people who are going to be working to try to convict people on behalf of the government. The people who they are trying to convince is the jury. We can get into how jury trial, jury selection works in a little bit, but the main idea behind plea bargaining is that the jury is going to be avoided. It is a trial avoiding mechanism to try to not have this trial even happen, no jury selection, none of that. So again, very different criminal court versus civil court. So if we look at what this looks like on a diagram, you have your defendant who is accused. Again, they are innocent until proven guilty, which I'll talk about in a little bit. And then you have the defense attorney. That person represents the defendant. They are their lawyer, their attorney, and can often be a public defender. The judge is in charge of making sure that that court case is heard in a fair way. Now, the prosecutor is going to be a government attorney that represents the government and is going to try to present the state's case against the defendant to try to prove them guilty. Now, I talked about this term district attorney. This is a system where the state or the county has a system that works to prosecute different people. So most of these are set up in different departments and have different teams. So you will have major crimes or homicide or special victims. There's all sorts of different aspects to this where it's a robust department of, in major cities, maybe hundreds of people working together. At a state level and at a federal level, you have something that's called the Attorney General. Now, this person is not often in the actual courtroom, but this is the top lawyer, the chief law enforcement officer for either a state or the federal government. And in the case of the federal government, is a cabinet position in the president's cabinet. Now, the last aspect of this is the jury. The jury is a set of peers. So they are people who are selected and they determine the verdict. They say, is the person innocent or are they guilty? And there's a whole process for how this works where as a citizen, you have to go to jury trial if you get, in my case, it was a letter in the mail that said that you had to show up to jury trial. And then if you are chosen for the jury, then you have to render this case. Now, one of the things that is important in how jury selection works is that the defendant and the defense attorney and the prosecutor have to agree on each member of the jury. So jury selection is a really important process that may be a very important part of this topic. Now, what's interesting to note here is that the jury is just in charge of determining that verdict. Now, they can recommend some sentencing, but if the defendant is proven guilty, the judge is then in charge of the sentencing in the courtroom. And this is going to be really important when we talk about plea bargaining, because plea bargaining is going to functionally change how all of this works. So if we look at a courtroom, pause the video right now. See if you can fill in who all of these different people are in the courtroom. Sure, there's like a stenographer and the witness and the bailiff and some things that we haven't talked about, but I think that this would really help you get a basic understanding of the different people, the different players that are going to be involved in a court case in the criminal justice system. So if we look at the criminal justice system, the term mass incarceration is used a lot. I highly recommend, there is a movie, 13th by Ava DuVernay on, I think it's free on YouTube right now, that talks all about the prison system and how the system of prisons in the United States has evolved to be huge and robust and incarcerate more people than any other country on planet Earth. And a part of this has been movements like the war on crime, the war on drugs, the Nixon and Reagan administration, and their development of the Bureau of Prisons. And I think that this is really important and a fundamental aspect to our topic that I definitely don't have enough time to talk about, but I highly recommend that you go out and watch that movie. Again, mass incarceration, the idea that lots and lots of people are being locked up and that our system of government, our democracy is founded on the idea of making sure that there are people who are not free in the land of the free. I think that there's a lot of distinctions on this topic, a lot of words that are important that I would never have enough time to talk about. But one of the important things here is that jail and prison are very different things. Typically, when you are arrested, when you are accused of a crime, you go to jail, whereas prison is somewhere where somebody goes once they have been convicted of a crime. There is a difference in types of charges, whether that charge is a felony charge, a misdemeanor charge. Again, we talked about how the federal judiciary is different than state courts, but the key thing here is that the federal judiciary has supremacy over the states. So they have the final say in determining what is and what isn't. The next thing is that there's all sorts of different court system. So it wouldn't shock me if there are people on this topic that talk about drug courts or other things like that to try to get some specific instances in which plea bargaining is just or unjust. The last thing here that I want to talk about is that there is a difference in sentencing, so concurrent versus consecutive. So concurrent would mean you serve all of these at the same time. So if you get 5 sentences for 10 years, if those are concurrent, you may be out of prison in 10 years, whereas if they were consecutive, that would be 50 years. And that terminology is really, really important when looking at this topic. Speaking of terminology, there are so many different legal terms on this topic that I have nowhere near enough time to talk about. We had a sort of key terms in the criminal justice system worksheet in my classes, and it ended up being like 10 pages long because there's just so many different terms that are important for us to know. So I highly recommend that you just go through and look at all of these different terms and make sure that you have a really good grasp and understanding of what all of these different jargon, almost debate words seem on this topic. I really think that there's a lot of vocabulary here that a lot of high school debaters are unfamiliar with, that it would behoove you to look at these terms. In addition to a lot of important terms on this topic, there's also a lot of important people that you should probably know about, because if you're not referencing them, other teams probably are. The first one of those is just the Supreme Court in general. There's 9 justices on the Supreme Court, including a Chief Justice. You should probably know the majority, how all of that works, different judges' proclivities to vote on different things, what it means to be appointed by a conservative, what conservative justices normally feel about the world, all sorts of aspects to that. I also think that it's important to know the Attorney General. I used this term earlier. I said that it is the Chief Law Enforcement Officer of the United States. This is currently Pam Bondi. They run the Department of Justice, or the DOJ, and they are a cabinet member in the executive branch. So they are the top cop of the land. This structure is also replicated at a state level. So there are also state attorney generals. In your area, it probably behooves you to know your attorney general, because people are probably going to reference local or state level cases, or, just cross-ex questions, things like that. Probably one of the most popular, one of the most prevalent people to be a attorney general is our former vice president, who was the Attorney General of California from 2011 to 2017. And there's a lot of people who, for lack of a better saying, really don't like former Vice President Harris. And that has to deal a lot with her being a prosecutor and her putting a lot of people behind bars when she was the Attorney General for the state of California. You also have different district attorneys' offices, which I've talked about prior, but it's probably important to know what your area looks like. So for instance, where I live, it functions at a county level. So there's all different aspects to how this functions within your state, within your region. And I think it's important to know all of the different people and aspects behind how the criminal justice system works in practicality rather than in theory. The last aspect of the criminal justice system that I want to talk about before we get into plea bargaining itself, finally, is the Constitution, because a lot of this is going to be really important background that you have to talk about plea bargaining. So the first concept is that innocent until proven guilty is not in the Constitution. It is rooted in the amendments. It's rooted in different court rulings that back this up, but there is nowhere in the Constitution that uses those words to reference anything, let alone the criminal justice system. Now, the amendments generally do this. So the Bill of Rights, the first 10 amendments, has a lot of this. So the Fifth Amendment is going to be really important on this topic, because the first thing that it does is that it establishes due process, sort of the fairness that everybody is allowed in court to operate the same way, and that nobody is given better or worse punishment or circumstances or treatment than other people. Everybody is treated as equals and gets the same process in the court system. You also, under the Fifth Amendment, have the right to remain silent. You can, quote unquote, plead the Fifth, where you do not have to self-incriminate against yourself in the court of law. The Sixth Amendment is also really important for our topic because the Sixth Amendment establishes the right to a trial by jury, the right to counsel, having to state the nature of which the defendant is accused, the right for the defendant to confront witnesses. All of this is grounded in the Sixth Amendment, and there's a really important court decision, Miranda versus Arizona, that is rooted in the Fifth and Sixth Amendments that establishes your Miranda rights. If you've seen a court TV show, a court YouTube video, you've probably heard this before, where generally a police officer tells somebody you have the right to remain silent. Anything you say can and will be held against you in the court of law. That is your Miranda rights. That is the judge, the judge can say it too, but that's the police officer saying anything from this point that you say can be used, construed against you in the court of law. So a lot of people, when they hear their Miranda rights, they invoke a lawyer. So that is important for how plea bargaining works, which we'll get to in a second. The Eighth Amendment establishes that there can be no cruel and unusual punishment, and the 14th Amendment is also really important on this topic because it not only establishes the due process clause, but it establishes how sort of fairness in legal proceedings should work. And these are all really important. I know this isn't like a constitution topic, but the idea of plea bargaining involves waiving these rights that you are given in the Constitution. So it's really important to understand how this functions and where these rights come from in order for us to even begin talking about plea bargaining, which I'm going to do now. Plea bargaining. Finally, Scott, you're talking about plea bargaining like 30 minutes into the video. Well, I think that the reason behind this is that there's a lot of important aspects to the criminal justice system that you have to know before we even get to talk about plea bargaining. But that time is now. So what's interesting to note is that if we look at the Constitution, that the Constitution actually says that all criminal trials must be done by a jury. So plea bargaining is actually not in the Constitution, and the wording of the Constitution, at least to me, seems antithetical to plea bargaining because it says that that criminal trial must be done by a jury. The couple things to note, which I'll get into in the history here, but plea bargaining is a real recent process, but more importantly, it involves waiving a lot of the constitutional rights that I just got done talking about. So, the Fifth Amendment, you would have to admit guilt. The Sixth Amendment, you give up the right to a jury trial. There's the potential for coercion. You don't get your due process. There's all sorts of aspects to this where the defendant is literally giving up their constitutional rights in order to gain some sort of benefit. So if we look at the history behind plea bargaining, unofficially, the idea of compounding has been an issue for a long time, where the victim of a crime agrees not to prosecute in order to get a payment for that crime. You see this in civil cases all of the time. However, in the United States, plea bargaining really didn't exist in any sort of fashion for a very long period of time, and we don't really see a lot of reports of plea bargaining until after the Civil War. In fact, before then, or even after then, courts really didn't want guilty pleas. It was seen as not something that was wanted because, again, the Constitution guarantees people a jury trial. Why wouldn't you do that? However, plea bargaining becomes a very dominant method at the end of the 19th century, beginning of the 20th century. And at the beginning of the 20th century, especially because of Prohibition, the U.S. criminal courts really start to get these guilty pleas, maybe not a plea bargain, but a guilty plea for a defendant. And that is where the roots of plea bargaining come from. In the 1960s, it's still really widely used, but there's still no Supreme Court ruling on it yet. That changes in 1970 with Brady versus United States, and that Court case affirmed plea bargaining as being constitutional and as being a part of the criminal justice system. Now, some really important aspects of this ruling were that the pleas must be knowingly given by the defendant, they must be voluntarily given, and they must not be inherently coercive. Now, that phrasing, inherently coercive, is a little misleading because in the next case here in 1978, it was actually ruled that threats, or more or less these coercive prosecutorial threats, are indeed constitutional. So I think that it's very interesting, and this is going to be a big source of debate on the topic as to whether or not they can be coercive. Are they coercive? How does all of this function? But regardless of that, historically in the present day, this is just how the criminal justice system operates. You see a quote here from a former Supreme Court justice that says, the U.S. criminal justice system is no longer a system of trials. It is just a system of pleas. And that is, seen in a criminal justice system where 95% plus, probably 97, 98% of convictions are plea bargained. Now, that's not cases, it's convictions. It's a very important distinction, but a large majority of these convictions don't see a jury. And I think that that is one of the fundamental questions that this topic is asking us. The thing I want to point out before we go any further is that the media and how media, TV, movies, etc. influences our reality really changes our perspective, and the reality behind these things is very different versus what we see on reality TV. So, for instance, personally, I think of the TV series Law & Order or Law & Order SVU. If you watch TV now, you might think of something like Suits or some YouTube episodes of seeing different court justices, and that how plea bargaining works in the movies is very different from how it actually works in reality. And while that is a good grounding to sort of gain some knowledge about the topic, it's not how the real world actually operates. So let's look at this. Earlier in this topic lecture, I had a different diagram, but it more or less said the same thing, where it broke down a courtroom, and it said, here's the defendant, they're accused of certain things, they're defended by their defense attorney, that might be a public defender if they don't have enough money, but that it could also be a lawyer, it could be an attorney, it could be someone like that. Now, when we introduce plea bargaining into this whole system, it is going to really, really, really change how this functions. And it's going to change by getting rid of the jury, because again, plea bargaining means the admission or the waiving of that right. So the verdict is no longer going to be something that the jury delivers. The other thing is that the district attorney or the prosecutor is going to be the person offering the deal. So maybe the judge doesn't have as much influences in the sentencing anymore because there is no trial, there is no jury, and the sentencing is something that is predetermined. Now, we're going to talk about this in a second, that plea bargaining is really difficult because it doesn't necessarily all work the same way, but more or less, this is what plea bargaining is going to do, where it's going to give that sentencing power to the prosecutor, and the judge is rather just going to approve that plea bargain rather than issue the sentence themselves. So it really changes how the criminal justice system works and how the application of criminal law works in society. So I think that this is a basic background on how it changes before we get into why all of these things matter. Just trying to drive home the basics one last time. Remember, in the United States, the Constitution gives the right to a jury trial to the defendant. So anybody who is accused of a crime inside of the United States, regardless of their citizenship or not, has the right to a jury trial. Plea bargaining is when that accused person, the defendant, gives up their right to a jury trial. They more or less are selling their right to a jury trial to the prosecution to gain some type of benefit. Now, I know I just had a diagram where I painted out the picture of what this looks like that I'll bring up here in a second, but I'm going to talk about plea bargaining in a general sense. It is not a static event that works one way. It is a dynamic process where every plea bargained agreement is very different. There are some cases where there's very little judicial involvement. There's some cases where the defense attorney really isn't involved in the negotiations at all. There's sometimes where the defendant is just given like 15 minutes to say yes or no. All of these work very different depending on the specificity of the specific case. So if I bring up the diagram that we had before, right, there's some instances where the judge might still approve sentencing. So this system might not be exactly like I have it diagrammed above or how I have talked about, but the basic idea is that the defendant is giving up their right to a jury trial because it is benefiting them in some way, shape, or form. However, the one thing that I think is constant is that the prosecution gets more power out of plea bargaining. Regardless of what the slice of that pie looks like, the prosecutorial power that the prosecutor has is just dramatically increased. Sure, the judge still has to approve it. The defendant can always not give up their right to a jury trial and go to trial. But plea bargaining massively leverages the prosecution and gives them a lot more power. In most instances, again, this might not be the case, but is mostly the case, that the prosecution is the one that determines the deal. A lot of times the sentence, the deal that's going to be agreed upon, is agreed on before the judge is even involved. Sometimes the defendant isn't even a part of the process. The judge and the prosecution are a part of it. So this process works very different depending on the circumstances. But the number one takeaway is that in some way, shape, or form, the prosecutor is getting way more power. And in most instances, the prosecution is getting sentencing power that was previously held by the judge. So the reason that this is important is that when we look at how that sentence is determined by the prosecutors, there's all sorts of factors that go into it that seem pretty unfair when you look at it, right? Especially when we're talking about things like the prosecution needs to have a guilty plea so that they can get reelected. A lot of these things, are really questionable. So when these sentencing guidelines are offered, when the prosecution gains more power, these factors become something that is looked at in what type of deal is the defendant given. And when we are determining sentences based off of all of these different aspects, it can lead to a system that may not be as just as we think it is, right? There's also different ideas behind this of concepts like mandatory minimum sentences, where certain, drug laws, for instance, required that somebody be put away for a certain period of time. How does that work? There's all sorts of aspects to this that have to deal with gender, race, past criminal offenses, all sorts of aspects that may be out of the defendant's control. And I think that this is really important because that sentence, that power is no longer held in the court of law. It's no longer held in a place that prioritizes things like due process and could easily get out of hand really, really, really fast. So a lot of these things are really important when we look at how plea bargaining changes how the original criminal justice system intended by the Constitution is really laid out. Now, this seems voluntary, right? I said the defendant has the total right to give up their right to a jury trial or not. They can choose not to sell it. However, there are a lot of instances where it just seems like a no-brainer because, I was reading a case how in Boston they were threatening people with 20 years in prison versus 2 months if you took a plea bargain. The other thing that's interesting here is that, like I was talking about in the history section, there may be some constitutional agreement with the ability to coerce. So definitionally, I think that there's a really valid argument that these coercive pleas are not even bad, but a function of how the pleas work. But they can't be coercive if the prosecutor doesn't hold them. If they go to a jury trial, there's no ability for that to happen. So I think that you're going to see a lot of people talk about how this increased prosecutorial power leads to coercive decisions, coercive pleas versus voluntary ones. Now, definitionally, you might have some problems there, but I think that these arguments are going to rely on things like forced wrongful convictions, getting people to agree that they're guilty for a very minimal sentence in order to, for instance, convict somebody else. So there's a lot of instances of like ratting or snitching where somebody who is convicted of a minor drug crime may snitch on whoever is above them for a lower sentence so that then the prosecutor can go after the bigger fish. And I think that all of this is very dynamic and works in how the criminal justice system with plea bargaining reaches convictions. But really, how do people even agree to these plea bargains in the first place? Now, the reason they agree is that they are gaining some type of benefit. When we look at plea bargaining, generally there's 4 different ways one can plea bargain. They can either plead guilty in exchange for a lighter sentence, so maybe instead of 20 years, you have 2 years. Charge bargaining would be when the defendant pleads guilty to a lower charge. So maybe somebody is charged with first-degree murder, and instead they plead guilty to assault or manslaughter or something like that. Fact bargaining would be when the defendant agrees to certain things in order for certain things not to be discussed. Count bargaining would be I'll agree on some things, but I won't agree on others. And all of these are different ways that plea bargaining can happen because there are different ways that the prosecutor can entice the defendant to take a plea bargain via what benefits they are specifically given. I think the biggest example of this, if you are doing any research on this topic, the number one current event that you're going to run into is Bryan Kohberger. So this individual murdered 4 University of Idaho students, and he was faced with the death penalty. He accepted a plea bargain where he pled guilty. He gets 4 consecutive life sentences. Remember, consecutive versus concurrent. That means they will be life, 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 not all at the same time. And he has no ability to get out of prison at all. So Bryan Kohberger had a plea agreement where he agreed to spend the rest of his life in prison, and the thing that he gave up is they are not going to seek the death penalty against him. So my question to you is, go back to the previous slide. What type of plea bargaining is this? Is there multiple types of plea bargaining at play here? How does this work? And I think that this is a really good exercise to determine how plea bargaining is actually working in today's society, especially in prevalent cases that a lot of our authors are going to talk about. Now, why would somebody take a plea bargain? The reason they would take a plea bargain is, like I said in the example of 20 years versus 2 months in Boston, people get a discount for pleading. And I think that in addition to this, there's also the idea that if you don't take the plea, maybe people are going to be harsher to you. Maybe the judge or prosecutor is going to seek a more harsh sentence because you didn't take the plea agreement. That plea deal operates in this shadow of a trial, and that punishment could really be something that is worth pleading over or not. You especially see a lot of plea bargains in cases of drug crimes, white-collar crimes, economic crimes, things like that. And I would assume that the reason behind that is that the consequences that they are facing isn't as much. Now, this sort of faces somebody with a prisoner's dilemma, especially in this 20 years versus 2 month scenario where, even if you're innocent, maybe you'll just take the lesser punishment because you don't want to risk going to trial because there is a non-zero chance that you could get that really long sentence. And that's not something that you are worth risking your life over or risking a lot of years of your life over. However, there's other people who say, I'm innocent. I'm not going to do that because I didn't do it. Now, there's lots of instances where there are people who take this route and are imprisoned for a very long period of time. I think that, the reason why a lot of people do take these is that reason. They're afraid of a guilty verdict, a long sentence, something like that, even if they are innocent, because that's a really long period of time. And a lot of times they think that it's just worth taking the deal over the risk that something bad could happen. A lot of it's kind of like debate calculus almost. So that is plea bargaining, the background, the basic history, all of that stuff. In the second video, I'm going to talk more about different debate arguments, the contentions, disads, all of that type of stuff. So if you were looking for that, that's in part 2. Part 1 was all the history, background. Hopefully it helped y'all out, and I will see you in part 2. Thank you. Bye.